Item number 78.
My lord, this is a quashing of FIR, my lord, which are registered for an offences under section 494.
मधुसूदन पांडे साहब ससुर लग रहे हैं, मधुवन पांडे
सर ये ब्रदर इन लॉ है, एप्लीकार्ड नंबर 1 ब्रदर इन लॉ है, 2 भी ब्रदर इन लॉ है।
जेठ है क्या?
हाँ सर, जेठानी
जेठ
सर।
और तीसरे
सर तीसरा जेठानी
जेठानी है
जी जी। हेलो द
FIR क्या है सर?
Hello, the FIR is found at page number, my lord, 11, my lord. The incident, my lord, as alleged, my lord, 10/6/21 with regard to the demand of dowry. The marriage was solemnized in the year 2016, and the FIR got registered on 11/9/23. In fact, if my lord may please to see the FIR, certainly, my lord, it is a case where it is seems to be that the entire incident is of a quarrel between the family member, not it is a case of a dowry. In fact, if my lord may please to see the FIR. If I may be permitted to read my and the last subsequent I am my lord. May I proceed?
Please.
Page number 30, my lord. I am reading the paragraph 12, my lord. I am reading 5th line, my lord. दिनांक 10/6/21 को 11 बजे हमारे पति दीपनारायण पांडे, जेठ मधुसूदन पांडे, मधुवन पांडे, जेठानी आराधना पांडे द्वारा सभी लोग बोले कि तुम्हारे माता पिता ने शादी के समय कुछ नहीं दिए हैं, अब तक तो मोटरसाइकिल और 1 लाख रुपए अपने पिता के यहाँ से लेकर आओ। तब मैं बोली मेरे माता पिता गरीब हैं, अपने हैसियत के अनुसार विदाई में सम्मान दहेज दिए हैं, अब नहीं दे सकते। तब पहले मेरे पति दीपनारायण पांडे 100 गालियां देकर लात घूसों से मारपीट करने लगे। जेठ मधुसूदन पांडे, मधुवन पांडे, आराधना पांडे बोले कि 100 इसको घर से भगा दो, और आराधना पांडे लपटकर मारपीट किया था। वह हमें मानसिक रूप से काफ़ी प्रताड़ित करते थे। तब भी मैं अभी तक अपने मर्यादा में रही। हमारे 2 लड़के हैं, एक बड़ा लड़का 6 साल है, उससे छोटा 4 साल का है। नाउ मैं लोग दिनांक 19/7/23 को पुनः हमारे पति दीपनारायण पांडे, जेठानी आराधना पांडे दहेज की मांग को लेकर बुरी बुरी गालियां देकर लपटकर लात घूसों से मारपीट।
आराधना के पांडे के खिलाफ मारने पीटने के स्पेसिफिक एलिगेशन?
यस मैं लोग।
अच्छा, जेठ जेठानी के खिलाफ उसको आखिरी में एक पर्टिकुलर वर्ड का इस्तेमाल करके घर से निकाल दो कहने के लिए एलिगेशन?
जी। This was an, if my lord may please to see the my lord page number 16, my lord. Page number 16 next to it. This was a complaint, in fact, my lord, which has been made by the husband, and judicial case for judicial separation has also been filed. A notice when received by her.
Sir, आप लोग
हाँ, that is my lord correct कि that is a matter of defense.
No, no. It is not a matter of defense. It has no relevance at all.
But my lord, it is to be taken as a defense at a.
Even then, मेरे हिसाब से तो ये it is not a relevant matter, क्योंकि वो सुप्रीम कोर्ट का जजमेंट भी कहता है. It has no relevance.
No, because the allegation seems to be done. वो incident जो बता रहे हैं 10/6/21 का और 11/9/23
है तो सही यार, specific allegation may be false according to you, but लेकिन है तो सही.
और 11 सर एक बार पेज नंबर 16 देख लें नेक्स्ट रेट.
देख लिया मैंने सर, आपकी टाइप डेक कंप्लेंट है.
यस यस, कि उसमें वो क्वेरल का एंटायर इंसिडेंट इज ऑफ क्वेरल मैम.
मेरे भाई ये आप सच बोल रहे हैं कि वो सच बोल रही है?
मालूम.
तो अगर आपकी ये कंप्लेंट सच पाई जाएगी तो उसको झूठा मानेंगे, और आप ये सच बोल रहे हैं, ये फाइंडिंग हम कैसे देते हैं? आपने बिल्कुल सच लिखा होगा, मैं कुछ नहीं कह रहा हूँ.
We are residing separately, we have no nexus.
मेरे भाई स्पेसिफिक एलिगेशन
that is there, but that is some malafidely been made, my lord.
मैं मेलाफाइड को कैसे ले लूँ उस पे? ये तो ट्रायल का मैटर है ना.
My lord, that is correct.
17
My lord, I will
1737
pray that it may be the merit order on merit maybe.
हाँ वही कर रहा हूँ. 17374/2024. This application under section 482 of CRPC has been filed seeking the following relief. The applicant number 1 and 2 are the elder brother-in-law, whereas the applicant number 3 is the wife of the applicant number 1. The respondent number 2 lodged an FIR on the allegation that she got married to Deepnarayan Pandey on 11/7/2016 as per Hindu rites and rituals. At the time of in the marriage, her parents had given sufficient dowry. For the first time, she stayed in her matrimonial house for 11 days. Thereafter, she came back to her parental home and was frequently visiting her matrimonial home as well as parental home. The things moved properly till 2020. On 10/6/2021 at 11 a.m., her husband Deep Narayan Pandey as well as the applicants started alleging that her parents have not given much dowry in the marriage and therefore she should bring an amount of rupees 1 lakh and as a motorcycle. When she replied that uh, the financial condition of her parents is not such that they can give an additional dowry, then her husband Deep Narayan Pandey, after abusing her filthily, started assaulting her by face and clothes. The applicants also insulting her by calling her kamini को हिंदी में लिख दिया, instigated her husband that she should be ousted, and the applicant number 3 also assaulted her. However, she continued to stay in her matrimonial house because she is having 2 children aged about 6 years and 4 years. On 19/7/2023, again her husband and the applicant number 3 started abusing her filthily and also assaulted her by face and blows and extended a threat to her life. The applicants number 1 and 2 also abused her and instigated that she should be ousted from her matrimonial house by calling her as कुतिया. अब bitch कर दीजिएगा उसको, पहले वाले में bitch करके bracket में कर दीजिएगा. Then she narrated the incident to her parents and came back to her matrimonial house along with her brother. Both children have been forcibly kept by her husband until then, and since then she is residing in her parental home. Thus, it was further alleged that her in-laws have never called her back to her matrimonial house, and they are always extending a threat that unless and until a motorcycle and an amount of rupees 1 lakh is not given, she should not be allowed to come back to her matrimonial house. Challenging the order passed, challenging the FIR lodged by the respondent number 2, it is submitted by counsel for the applicant that the husband of the respondent number 2 had made a police complaint on 27/2023, whereas the FIR in question was lodged on 10/11/2023. It is further submitted that the applicant of the respondent number 2 has filed a petition under Section 10 of Hindu Marriage Act. And after receiving the said notices, the respondent number 2 has lodged the FIR by way of counterblast, and the allegations are false. Per contra, the application is vehemently opposed by counsel for the state. Next, heard the learned counsel for the petition. Before considering the submissions made by the counsel for the petitioner, this court would like to consider the scope of interference at this stage. So, judgments like that. Thus, it is clear that this court can quash the proceedings only if the uncontroverted allegations do not make out an offense, and this court can't conduct a mini trial at this stage. To find out the correctness of the allegations. So far as the complaint made by the husband of the respondent number 2, which has been filed as an annexure P2, is concerned, the same cannot be relied upon because at this stage, this court cannot hold that the allegations made in the complaint are correct. It is a question of defense liable to be proved by the applicants in the trial. So far as the institution of petition under Section 10 of Hindu Marriage Act is concerned, it is suffice to mention here that merely because the FIR was lodged after the institution of the said application, the proceedings, the FIR cannot be quashed on the ground of counterblast. The Supreme Court in the case of Pratibha versus Rameshwari Devi reported in 2007, volume 12, SCC page so and so, has held as under. Furthermore, since merely because the wife did not lodge the FIR at the first instance and maintained silence in order to save her marital life, then it cannot be said that the allegations are afterthought. If the wife, after realizing that her husband has crossed all the limits, thereby closing the chances of reconciliation, and if it decides to lodge the FIR with regard to the cruelty meted out to her, then it cannot be said that the allegations made in the FIR are false or are afterthought. Full stop. Considering the totality of the facts and circumstances of the case, this court is of considered opinion that when there are specific allegations with date there are specific allegations against the applicants with date and the role played by them, no case is made out warranting interference.
My lord, may I make one additional submission? My lord, Annexure A4 I have filed, my lord, they are all are residing separately, my lord. Annexure A4, my lord, along with my stay application. The Samagra idea there, this point also we incorporated.
Yeah, कहाँ रह रहे हैं आप
सर
लोग?
ये अलग-अलग उनका सबका
कहाँ रह रहे हैं?
सर कॉलोनी तो सेम है, कॉलोनी सेम।
At this stage, it is submitted by counsel for the petitioner applicants that although they are residing in the same colony, but are the resident of the different house.
My
But they are residing in a different house. Consider the submissions made by counsel for the applicant. The applicant has filed this Samagra ID to show that they are the residents of ward number 13, Anuppur, Zone 1, Municipal Council, Anuppur, District Anuppur. From the complaint which was lodged by the husband of the respondent number 2, it is clear that he has also disclosed his address as Anuppur, ward number 13, District Anuppur. Thus, prima facie, it appears that the applicants and the husband of the respondent number 2 were residing in the same premises. However, it is for the applicants to prove that they were residing separately and having no access to the residence of each and every residence of the respondent number 2. Since the allegations made against the applicants are specific and cannot be said to be vague, general, and omnibus, therefore no case is made out warranting interference. The application fails and is hereby dismissed.
Overlays.